All right, so our next conversation, we're going to be talking about intellectual property and IP, and I'm actually really excited for this conversation because I feel like it's going to be free counseling for me because I'm just going to ask questions that are relevant to me. I'm just kidding. But I talked to Adam quite a bit about these kind of questions that I have. I think AI is incredibly interesting, of course, but I'm really think that we're going to have a Napster moment with AI. We already kind of are having it when you think about Anthropic. And when I say a Napster moment, what I mean is that brands didn't really, the record labels didn't care a whole lot about Napster when it first came out. It was like, oh yeah, have fun, doing what you're doing. And then all of a sudden it's like, well, wait a second, this is actually really hitting our bottom line. And sure enough, we have the way that we consume, music today that is, a direct reflection of that. So I think similarly, when it comes to products and brand IP, we'll see something similar here where all of a sudden brands are thinking, wait a second, you're learning on my data. So with that, please welcome to the stage, Adam Philipp with AEON Law. Yeah, do kind of like a loopy. Let me test your mic. Hello, Adam. How are you doing today?
Doing well, thank you.
Fantastic. Adam, let's just go from the beginning. Where were you born? No, I'm just kidding. Why don't you tell us a little bit about what you do and the focus of your practice, et cetera.
So I run an intellectual property law firm called AEON Law. We do all things intellectual property. And in case you don't know what intellectual property is, that's the umbrella term that covers patents, trademarks, copyrights, and trade secrets. And primarily when we're talking about brands, we're going to be talking about trademarks.
Yeah. So I wanted to have this conversation with Adam for a number of reasons. When we think about what these AI models are learning off of, they're learning off of open information, scraping the web, et cetera. And, I use this as an example. We have a product called Mint Loops, which is an app inside of the Shopify App Store. And in creating my app, I needed to create basically a test store. So I created a test store that was a woman's handbag store. I called it Johnny Blanco. So if you ever see that come out, maybe that'll be a thing. But what I did is I put in some descriptions for what I wanted these handbags to look like. And I, simulated or, used variations of, descriptions on, clutch purse, with, chestnut leather color, things like that, right? And long story short, the imagery that came back was incredible. It looked really nice. It looked, obviously it had to have learned that from somewhere. So someone's brand IP has been scraped, to make these things. So that's kind of the impetus of this conversation.
Well, we're really in the cutting edge of this. Can you use other people's content for training? And when you know that somebody else has copyrighted information and you automatically get a copyright as soon as you photograph something, the photographer owns that copyright. The person who clicks the shutter owns the copyright. And if they're employed by a company, that company owns that copyrighted image. And when they're putting it out, if other people are training off of that data, you either need permission in forms of explicit permission or a license, or you must have done something, or you're using it under what's known as fair use. And fair use the courts have a multi-factor test where they look at what is permissible use. And there are two recent training cases that came down. The really interesting one that's just, we're 0-day wear discussions on this, is Anthropic, where there were two sets of book information that they trained their AI on. One, they bought hundreds of thousands of books, chopped off the spines, and fed the pages through a scanner. Court said, fine, if you want to destroy 1 million books, absolutely okay to train your data on that. Because you bought and paid for those books. It's like, if you bought a book, do you have permission to read it? Yes, you do. The other data they had, though, were these pirated databases of books. And no, they didn't have permission to read that information. That was pirated data, copyright infringement. And the judge in that case just gave preliminary permission for those authors to have a class action lawsuit against Anthropic. And a class action lawsuit with hundreds of thousands of authors, even for a company the size of Anthropic, could be a company-killing event. So, to be seen.
That's crazy. It's really interesting to think about that, cutting off the spine and feeding it through is okay, right? Because you're thinking, in my mind, I'm thinking, well, it's still the content, but because in this context, it seems like, well, you own that content because you purchased it from that, or what makes it okay?
So you don't own the content, you own that physical book.
Got it.
And so there's this doctrine known as the first sale doctrine. So if you purchase a thing, if you purchase a Buzz Lightyear toy, at what used to be Toys R Us, and you attach an M80 to it because you want to see how big of an explosion your Buzz Lightyear will make blasting off into space. Great, you can destroy that because you went to a retail store and you bought it, and Pixar and Disney exhausted all of their IP rights at the time of that sale. They can't tell you what you can do with it. That's the reason why software companies don't sell you software. They license you the software. So they're not transferring the ownership rights. They're just giving you permission to use it because they want to retain control over what you can do. Yeah. But if you have a true retail sale in a sense of a retail commercial transaction, then the person who buys that retail thing, usually all the IP rights are paid up and no one owes anything else to anybody afterwards.
Yeah. So where my mind is going with that is, okay, so clear on the book example. So now let's say I purchase a Gucci handbag.
Yeah.
And let's say I purchase rice. I buy a Gucci handbag, I buy a Louis Vuitton purse, and I start taking photos of these items.
Yeah.
Can I learn off of the photos that I took of these items because I have ownership of the purse?
So you can probably learn off of those photos, but you don't own the brand Gucci.
Right.
Or you don't own the Hermes. You don't own Birkin. And that was one of the recent cases with the Meta Birkins case, where this artist created a bunch of NFTs that he called Meta Birkins. And Hermes was not
associated or affiliated or pleased.
They were not pleased about this at all and sued. And this is where we get the difference between the IP ownership and the physical product, in that they got damages that they were able to recapture all of the artist's profits, and there were some punitive damages for all relating to trademark infringement and damaging their brand. But the people that owned the Meta Birkins NFTs got to keep those. Those were not clawed back because those were still viewed as artistic works. And so the individual works, the owners got to keep those, but they couldn't go around saying that they were Hermes or misusing that brand as well.
Got it. So, okay. So though I cannot represent it as being the brand, but so in a hypothetical, because I would not do this, but in a hypothetical, if I took a picture of a Gucci bag and I make my own bag that looks like it based off of what I learned by taking my photo of the Gucci bag, is that similar to the book example?
Well, so this is where you get the lawyer's answer, and the lawyer's answer. It depends.
Yeah.
Because there can be other intellectual property rights. So, did you hear about the Jack Daniels case?
No.
So, a squeaky toy company made a dog toy that looked like a Jack Daniels bottle. And it wasn't Jack Daniels. They called it Bad Spaniels. And on the label it said, 90% poo and doing number 2 on your Tennessee carpet. It was very much a parody and an amusing. It was meant to be humorous, and the courts eventually said, well, no one is going to be confused that this is a Jack Daniels bottle. But under trademark law, if you have a famous trademark, there's something known as dilution. If you misuse that trademark in commerce, they can sue you for damaging their brand. And they won on that grounds. So even though no one was going to be confused as to trademark infringement, it's still the brand Jack Daniels was slightly damaged by that experience, and they were so entitled to claim damages for that damage to their brand. Because a trademark is a legal bucket that holds your reputation.
Yeah.
And so if you have a big enough bucket that it's eligible for dilution protection, then you can damage it. You can get damages for somebody damaging that bucket, so to speak.
Yeah, interesting. So, what would you say are the top things that a brand should be thinking about when it comes to securing their IP?
Well, from the trademark side, I usually tell my clients, until you've committed to spending money on actually marketing your brand, don't worry about protecting the trademark, because you don't have enough there to protect, unless you have an incredible brand or logo that you're sure you're going to be using in the future. Because it's much cheaper to secure it and get federal registration early on than to fix problems later on, to try and claw back a domain name or to go back and get a name that somebody else has started using. So it's about 10 times more expensive to fix the problem than to just avoid it in the first place by getting it registered. So as a rule of thumb, if you're going to spend about $5,000 in marketing at that you've committed to do that, that's about when you would think about registering your trademark.
Yeah, makes sense. Going back to call it the models that we're learning off of and so forth is, what problems do you see happening or potentially happening, with that right now? We talked about this Anthropic scenario in my hypothetical, but what problems are you predicting in your crystal ball?
So there's all kinds of problems that we can see. I mean, making counterfeits is so easy now that the law is trying to catch up with the death by 1,000 cuts you get from counterfeits. But they actually have some interesting tools that they've developed. There's something known as a Schedule A litigation, where instead of suing individual counterfeiters, you will find all the counterfeits that you can find on a single platform. So everything that you found on TikTok, everything that you found at Amazon, and you sue the products preemptively, and you sue the shops preemptively, and it forces the platform to go in and freeze the shops and freeze all of their assets. And then you solve the problem afterwards. But you preserve those assets, so it's a way to keep the cockroaches from running away when you flip on the lights. So you freeze them in place beforehand, and you freeze their ill-gotten gains ahead of time.
So that Schedule A, it's almost like a demand letter to the platform saying, "Hey."
So it's much more. You actually file the litigation in court. You name all the listings and the platform, and the court orders the platform to secure all of the assets before notifying any of the shops. And so there are ways that that you can fight back. But in the age of TikTok and viral brand issues, the courts are trying to figure out ways to stay abreast.
Yeah. I feel like we need to talk more through that because I'm just spinning through some ideas with what we do on how we can deploy that. But yeah, for those that aren't aware, counterfeit goods is a $3 trillion industry. It's really big. It's also the underbelly of a lot of very nefarious things. So like when you think about things like sex trafficking or drug trade, a lot of that can be funded by counterfeit goods industry. So it's a much bigger deal than people kind of think it to be. On a side note, we actually wrote like a 9-part blog series about counterfeits, and it's called Rebuilding Trust in Luxury Markets. So if you go to niftmint.com on the /news, you can read that article. But yeah, it's funny because there's a whole different types of reasons as to why someone might buy a counterfeit good. There's even people that like love to buy them and like brag about it. Like it's a whole thing. But for us, we really think about, how do you make sure that the product itself is authentic. There's, I think, some methods that brands are also going about with doing that right now when it comes to RFID and NFC technology. There's some mandates in the European Union that are going to make it so that physical goods have to have these detectors in them, RFID, NFC, or QR code. For us, we think that's only a part-way solution, though, because that does a good job of letting you the origination of the product, but it doesn't necessarily map to ownership. And so when you have a tokenized digital twin of a product, now you have a proof of ownership. And so that's essentially what we do at Niftmint, was we tie this proof of ownership to, the physical good.
And it's possible to own the physical good where one person owns the physical good and somebody else owns the IP rights. So an artist can sell their painting, but still keep the copyright in the painting. So the owner of the painting can hang the painting up, but they don't have the rights to duplicate that painting and make all the subsequent art prints or everything off of that. Same thing with somebody that might have a luxury good item of some kind, and having a cryptographic or digital twin of that would, allow them to show proof of ownership, but it still wouldn't allow them to create counterfeits of that product or duplicates of it.
Yeah, definitely. I want to open up to questions. Does anybody have a question for Adam? Would you mind going to the microphone so we can pick up your question?
I might have too many questions for you. When you're talking about merchandise, I'll start here. Copying an IP, I'm involved in a food product. So there's different ways you could copy that. And where do you start with that? Because you could copy its image, you could copy its chemical brand. How do I look at that, I guess?
Okay, so food is interesting. So copyright law protects creative expression, but it doesn't protect facts. So you can't copyright a phone book, which is just an alphabetical listing of names. It's just the fact. These are the people that has phone numbers listed in alphabetical order. There's nothing creative about that. Same thing with recipes. If the ingredients list and proportions are not protectable by copyright, there's no protection there. The description of how to combine those ingredients is protectable. And so if you had food products that were produced just from ingredients list, not protectable. If you follow somebody else's instructions, you might argue that that's transformative and that the food product that you create is not the instructions. You can't look at the Mugu Gai pan and get back to what the recipe was that caused you to create that particular form of the dish. With food products, it's a more recognized and safer area. Usually the creativity that's involved in creating that individual dish is transformative enough that even if you're creating it out of somebody else's cookbook, you're not going to be sued for creating that dish.
So that's very helpful. Thank you.
But I'm not your lawyer, and this is not legal advice, and it's worth exactly what you paid for it.
Well, we should talk about that after. So I would say that this brand of food product is at least 65% IP. It's the way, it's the design, it's the feel. That's the way. That's the traction I'm getting already before the food product even exists. It's like, wow, that's...
And when you say IP, what kind of IP were you talking?
It's creative, and it's the way it's presented. There's a logo that can easily be copied.
Okay, so logo is going to be protected by trademark. And there are certain... if there's a really distinctive aspect of goods of some kind that isn't just a word or a logo, sometimes that can be protected by trademark-like protection. So the Jack Daniel's bottle has a very distinctive shape, which was part of the subject of that Bad Spaniels case. If I say Owings Corning insulation, what color is that?
Pink. It's been a long time.
Pink.
Yeah.
with Pink Panther as their partner
I remember.
logo, but that pink characteristic, they added that arbitrarily in there, so it's distinctive. If you go into Home Depot, every single tool company has their color, so you know you're getting a Makita or a DeWalt or a Milwaukee.
Okay.
Let's have you two finish.
Yeah, let's afterwards. Thank you very much.
Yeah, come on up, bro.
Many of the technology products and also many of the products that are actually made around the world are actually subcontracted to be manufactured actually all of in Southeast Asia and Asia. That's just a fact. So what's happened most recently, I'm not sure if you're aware of this, that De Beers, which is the famous Dutch South African company, what they just they're falling apart. Why? Because in China they've discovered a synthetic way to produce diamonds, and it's crashing the whole diamond market. This is just one perfect example. Now, when I was bringing microcomputer technologies to the world from Taiwan, Taiwan was an incredible place for counterfeiting. Taiwan is now one of the leading places where they protect IP, and that's probably going to happen to China as well. As everything migrates to Southeast Asia, it's just what country is going to get legal, like get milk. They're going to get legal eventually when they have all the technology and all the knowledge. So what it really is you have to follow the globalization of things and the manufacturing of things and the outsourcing of things. Actually, you think your Gucci bag is made in America? No, it's not. I'm sorry, made in the West. What's
the question?
Well, I wanted to make an observation because I've been in the manufacturing side in Asia for decades. I did want to relay this to NFC technology because I brought that to the world for Gemalto, which is now Thales. And NFC is actually very, very important to protect the technology. The other important thing is embedded security in chips, and I was also involved in all of that technology. Just an observation. That's all I wanted to say. Is there a question? There might be. I'll chat privately with you.
Okay.
All right. Any last question? Okay. Well, Adam, thank you for this great conversation. I'm sure you'll get a lot of people coming up to you here afterwards. But what is a good way for people to connect with you or follow up with you?
So easiest way is going to AEON Law, AEONLAW.com. And I do need to duck out early, but one of my colleagues, Jonathan from AEON Law, is right here. And he's happy to take questions. And patent attorney and trademark attorney over here, so he can handle those. But I'll be around for 1 minute before ducking out.
Okay. Well, thank you so much, Adam. I appreciate it.